Start by welcoming those in the internet land to our Greenway Chambers CPD on arbitration in light of two significant decisions that were made by the High Court in 2024. The first is one that I've been involved in for quite some time, Tesseract and Pascale Constructions, and the second is CBI Contractors and Chevron. If I could introduce myself to those that are online and to the one person that's attended here today that we're very grateful for. It's not often, two people. It's not often the panel outnumbers the audience, but here we are. But nonetheless, we're hoping others will turn up in due course. But nonetheless, it's all being recorded for posterity, and those that have a look at it later can hopefully gather something from it. My name is Frank Hicks. I'm Senior Counsel here at Greenway since the commencement of these chambers. Most of my work is in building and construction, litigation and arbitration. And I'm joined by Stephen and Adele. If you'd like to introduce yourselves briefly.
Thank you, Frank. Yes, Stephen Epp, Junior at Greenway Chambers and also practicing in building construction and arbitration and litigation. Thank you very much.
My name's Adele Carr. I'm also a junior member of Chambers, and similar to Stephen and Frank, practice in building and construction, infrastructure, and appear in arbitrations in those spaces.
Well, we're going to assume that those that are in attendance as part of the audience have a degree of familiarity with these two cases, so we won't spend a lot of time going through them. Stephen and I did a presentation last week on the law arising from Tesseract International and Pascale Construction, and if you wanted to know more about the considered views of the majority and the minority, then that would be the CPD to look at. We are going to focus in this CPD on very much the practicalities arising from these two decisions and how they may affect the approach to arbitral proceedings for practitioners, what one needs to look out for, what one needs to consider, both from the very start, the conception of arbitration being the agreement to arbitrate that is often incorporated as part of a larger contract involving the performance of works or the provision of services, all the way through to the potential to resist the enforcement of an award or an appeal under the various statutory provisions. We will be focusing on the domestic arbitrations today rather than the international. The international has its own regime and legislation, of course, but for today's purposes, we'll be focusing on the domestic arbitrations with particular reference to the AKICA rules, together with the New South Wales Commercial Arbitration Act. If I could just then perhaps briefly deal with the decision of Tesseract and Pascale Constructions, a matter in which, as I said, I appeared for Pascale Constructions and continue to appear as the arbitration proceeds. It was a High Court decision on a question of law arising from a reference under the South Australian Commercial Arbitration Act, seeking clarification as to whether or not the relevant proportionate liability provisions under the South Australian legislation and the Commonwealth legislation could be invoked as part of that arbitral process. At first instance, although it was heard by the South Australian Court of Appeal, it was held consistent with other decisions in Tasmania, Victoria and in Western Australia that proportionate liability was not available under the South Australian law, although in Western Australia and Tasmania the provision or the allowance to opt out of the proportionate liability provisions existed, and it was very much part of the decision of each of those cases, Woods Bagot and Curtin University and Aquagenics, that the agreement to arbitrate and the various provisions of the contract did represent an opting out of the regime. I won't dwell too much on the majority decisions, not least of which is because they are a little bit painful for me to read as I came second in the High Court, but I will just make reference to the fact that it was observed in the decisions of the Chief Justice, Justice Gageler, as well as Justices Gordon and Gleeson, that the proportionate liability regime had key provisions or key operative provisions which were directed towards the allocation of liability and the limit of liability for any wrongdoer to the extent that their wrongdoing or their breach actually caused loss and damage. So they were very much focused on the different parts of each of the regime, both the state and Commonwealth, to determine, as I say, whether the arbitrator could apply what were the key provisions or the integral features of the regime as described, as opposed to the way in which the South Australian Court of Appeal approached it, and indeed the way in which the minority of Justices Stewart and Edelman in separate decisions approached it, which was that each of these regimes was indeed a whole regime, and to apply only part but not all, and in particular the provisions associated with joinder, the giving of notice, and other particular bespoke features that pertain to the South Australian legislation, would be to apply something less than what the Parliament and the Legislature in each case had intended. And indeed, Justice Stewart, in possibly the strongest terms, described the application of part but not all as a distorted parody of what was intended by the regime. Not a phrase that I used, but nonetheless one that he did. What I did want to focus on, having looked at those matters, is what each of the minority judges said about the impact of the decision in that case on the practice of arbitration. And each of Justice Edelman and Stewart made observation as to the impact of what was decided by the majority, I should say, on the practice of arbitration. The first was in a section of Justice Edelman's decision headed Postscript, which is paragraph 225, in which he described the impact of the changed decision on the practice of arbitration, given the widespread consensus concerning the inapplicability of proportionate liability schemes in arbitration prior to this particular decision. And he went on to observe that it may be that a contract may contain an arbitration agreement to include provisions that limit the liability, tying of action or quantum of damages of one or more of the parties of the contract, and it may very well be that those arbitration agreements can also exclude proportionate liability. Justice Stewart, in his decision, also made fairly strong comments at about paragraphs 281 and following, observing that the issue of proportionate liability ought to have been determined that either the entire arbitration was either inoperative or incapable of being performed where it was raised. At paragraph 283, it was observed that the result in this appeal highlights the limitations of arbitration. The fashionable trumpeting of arbitral resolution of disputes may have overstated its virtues. Some disputes are better resolved in a court of law. Now, whether or not you think that's correct or not, what we're here to do today is to try to examine the various features of arbitration, going through the process of it, so that we can observe where the features of arbitration and its ability to be utilised in any commercial context can be accommodated, having regard to this particular decision. So that was what I wanted to say briefly by way of opening remarks. I'm pleased to say that we've had further people arrive in person, and now the attendees exceed the number of panellists, so that's good. And I'm just going to hand over to Adele for her to give a brief overview of the decision in CBI Contractors or Constructors and Chevron.
Thank you, Frank. As Frank said, I'll just give a brief overview of the case. It is assumed that there is familiarity with this case, given that it has been handed down some time ago. By way of short background, the arbitration concerned a gas project in which CBI agreed to provide staff and Chevron agreed to reimburse CBI in respect of those costs. Now, there was an issue in respect of how those costs were to be reimbursed in terms of the amounts. CBI claimed that Chevron had underpaid it for costs based on actual costs, whereas the amount claimed by CBI was in respect of that it should have been paid in respect of certain rates. Because of the issue in respect of liability and quantum, the tribunal identified that it could and should bifurcate the dispute, and it did so with respect to identifying that in respect of the first hearing, that all issues of liability would be determined, and that in respect of the second hearing, all issues of quantum would be determined. Following the first hearing, the tribunal issued its first interim award, and it rejected CBI's argument that it could recover its staff costs on the basis of rates. The tribunal allowed CBI to replead its quantum case as a consequence. It was at this time that CBI sought to agitate liability, but on a different basis. And it was the basis that staff costs should be calculated, referred to by what was referred to as the contract criteria case. This new claim essentially was objected to by Chevron on the basis that the issues of liability had been finally and fully determined, thereby raising various issues estoppel arguments, and that consequently the tribunal could not hear this argument. So effectively it was functus. The tribunal didn't accept Chevron's submissions and allowed the amendment, and that was the subject of a second interim award. It was that award that Chevron appealed to the Western Australian Supreme Court, seeking to set aside the second interim award pursuant to section 34(2)(a)(3) of the Commercial Arbitration Act. And if I could just briefly read out the section, because it is important in respect of the first ground that the High Court considered. This section is modelled in other jurisdictions, obviously under the model law, and it provides an arbitral award may be set aside by the court only if the party making the application furnishes proof that the award deals with a dispute not contemplated by or nor falling within the terms of the submission to arbitration, or contains decisions on matters beyond the scope of the submission to arbitration. The Supreme Court and the Western Australian Court of Appeal agreed with Chevron, as did the High Court. There were two arguments before the High Court. The first one, which is the most important one that we're going to be considering tonight, is in respect of that CBI drew a distinction between a decision for error of jurisdiction, for which section 34(2)(a)(3), which I just read out, permits the court to intervene, as opposed to an error within jurisdiction in which the court cannot intervene. The latter was how CBI described the tribunal's second interim award. The majority found that the first interim award was final and binding, and therefore there was no further authority to reconsider or further consider the subject matter of that award. What's important to note is that the majority considered that the arbitration agreement in this particular matter provided that any dispute would be exclusively finally settled and that any award would be final and binding. And that was consistent also with the procedural rules, and in that arbitration it was the unstructural rules that apply, which also provide that the tribunal could make separate awards on different issues at different times, and that such awards would be final and binding. Now, those procedural rules do reflect the Akika rules, which Frank mentioned before that we would be focusing on tonight. The High Court found that the tribunal was consequently in excess of jurisdiction when it revisited the issue in respect of liability, so CBI's subsequent claim, and that it had already dealt with it in the first interim award. Consequently, the High Court found that the Supreme Court was empowered under section 34(2)(a)(3) of the Commercial Arbitration Act to consider Chevron's application. Now, although the second ground that was argued before the High Court is not relevant to tonight, just to briefly cover it, CBI's argument related to the standard of review to be applied by a court on an application for set-asiding the award under section 34(2)(a)(3) of the Commercial Arbitration Act. The primary judge adopted a de novo review of the correctness of the tribunal's finding that it was not functus, which was not challenged in the Court of Appeal. Consequently, CBI submitted that the Court of Appeal should have afforded significant deference to the arbitrator's decision. And this was rejected by all of the judges of the High Court, upholding that the primary judge's finding that the correct standard was a de novo review. This is, as we know, a hearing at the matter afresh and a decision made on the evidence presented in court, including evidence not before the tribunal. Obviously, this type of review is to be contrasted to a rehearing, or a judicial review. And the High Court found that there was not to be any difference in respect of the tribunal's decision.
All right. So with those brief remarks concerning the two cases having been made out, what we propose to do now is to look at the process of arbitration from, as I say, conception to award and enforcement, and to see how these decisions might inform each stage of that process in terms of the matters to be considered procedurally. Now, the first or starting point is drafting an arbitration agreement. Stephen, did you want to start off looking at some of these items and perhaps make some observations concerning it?
Well, one of the issues arising out of Tesseract is a consideration as to whether the possible impact of it can be ameliorated by, in effect, incorporating into your arbitration agreement provisions for all the downstream parties' interests to be aligned in the arbitration agreement. And the way the consideration of that issue would possibly flow is this. The contracting parties at the negotiation stage would effectively get together and consider whether issues of joinder of downstream parties could be dealt with at that early inception point in time. The obvious advantage of doing that is that you don't then, years later, get to a point of dispute and then parties then work out, well, I need to join a third party, and there are obviously difficulties in joining third parties to an arbitral dispute in circumstances where the third party doesn't consent. So an issue for consideration for those in particular drafting arbitration agreements, can you effectively bring all necessarily affected parties into the scope of the arbitration agreement at that very early stage?
I think another lesson, or at least observation that was made in Tesseract, is that one really needs to give careful consideration to the arbitration agreement as part of the broader deal. Arbitration agreements frequently do not feature as standalone arrangements. They are incorporated, often bolted on, if I can put it that way, to a project agreement. It's often done by transactional lawyers who have perhaps something of a disdain for the back end of the litigation, or arbitration lawyers. And at the time that all the parties are full of hope and excitement as to this wonderfully profitable project they're all going to be involved in, and therefore the prospect of dispute is very much a dark cloud on the horizon that they don't want to necessarily see. But it is important in the context of a project document, or indeed any agreement for services, that one gives particular consideration to arbitration as a forum, and what exactly is the arbitral process and the rules that are going to be applicable to the dispute. One of the things that Justice Edelman observed in his postscript was that a sufficiently clear context or sufficiently clear terms might be sufficient in arbitration agreements to exclude proportionate liability schemes from the rules of law chosen by the parties applicable to the substance of the dispute. One of the things that arose in Tesseract was that there was an arbitration agreement, but the parties had not turned their mind as to the rules of law that would be applicable. Now, because the project was in South Australia, it simply proceeded on the basis that that was the law, because that's where the arbitration was, that was where the project was. There was some debate at each level before the court as to whether or not the parties had made a choice under Section 28(1) of the Commercial Arbitration Act, which has an equivalent provision in New South Wales, or whether or not it was the rules of law applicable in the place where the arbitration was to take place. And that was Section 28(3), which also has an analogue in the New South Wales Commercial Arbitration Act. But one of the lessons to take out of Tesseract is that it's important to give consideration and thought to what might be the subject of your dispute under the arbitral agreement or arbitration agreement, and is that the best forum? It may very well be, given the other benefits of privacy, confidentiality, etc., that arises from arbitration, but it may not, given the nature of the dispute that arises. There are other aspects that need to be considered. Adele, do you want to have a look at those for us, please?
Certainly. So as Frank said, in relation to the proportionate liability issues, the seat of the arbitration, the substantive law, they're all considerations that need to be considered as to where the procedural and the law that's going to apply to interpreting the dispute, which sometimes is where the hearing is located in the seat, but not always. And these are sometimes things that aren't considered at the time of drafting and sometimes need to be implied into the drafting.
I think that's what Justice Edelman referred to as sufficiently clear context.
Indeed.
As opposed to sufficiently clear terms. The other thing that we've just noted as part of this particular aspect is the question of a right of appeal. And practitioners in this area will know that certainly under the New South Wales legislation, one needs agreement before one can seek the leave of the court to appeal on a question of law. This is in distinction to the situation in the United Kingdom, which has an opt-out arrangement rather than opt-in.
Which what we used to have.
Which is
before.
what we used to have under the old Commercial Arbitration Act. And of course, it's also quite significant now, given the other changes to the Commercial Arbitration Act, that practitioners will be familiar with, particularly Section 8, which compels parties to arbitration if that is their agreement. But there are limited exceptions, of course. But generally speaking, if one finds oneself in an arbitral regime under the terms of the contract, notwithstanding the dispute may be inapt for arbitration for one reason or another, nonetheless, you may very well find that there is no option to do anything other than seek to resolve the dispute in that context.
And the courts are so willing to stay any litigation.
Well, they will stay almost always and refer immediately to arbitration. One of the things that gives rise to is the question of expedited arbitration under the AKICA rules. Stephen, I think we've had some experience with that one, haven't we? And what it was thought a good idea, no doubt, at the time the contract was made, but perhaps you could talk a little bit about that.
Yes, I think there are a couple of issues to think about when drafting an arbitration agreement and considering expedited arbitration. We're going to come back to possibly later on in the presentation some of the issues about expedited arbitration. But just at this point in time, that is when those who are drafting arbitration agreements, the fundamental issue in our experience has been to consider whether the project to be delivered pursuant to this contract is a suitable vehicle for dispute resolution under an expedited arbitration. And we've had particular experience where the contract model that we were asked to advise on and the underlying dispute was wholly incompatible with the actual concept of expedited arbitration. Pausing there, expedited arbitration is a relatively newer feature of arbitration practice, and it has a lot of advantages if the nature of the dispute is relatively small. AKICA's rules actually provide that it should be suitable for a dispute for less than $5 million. Difficulties arise when those who are drafting their arbitration agreements think that if you have an expedited arbitration, you will minimise your legal costs, because, as we'll get to later on, your right to have an oral hearing can be extremely limited or constrained, and then there are very strict timeframes within which an award has to be delivered, all consistent with the notion of expedition. But where you've got a dispute and that's wholly incompatible, as I say, that has serious ramifications as to whether any award that's produced under this expedited arbitration can in fact be enforced. So I think that's all I wish to say about that at this point in time.
Well, it does nicely lead into the notice of dispute, though, and what should be arbitrated.
Yeah, so once you've established what your arbitration agreement is, in the contemplation, possibly expectation that the project will end up in contest or disputation, and that has arisen, then ordinarily the first step is the issuing of a notice of dispute. And it often gives rise to the same matters in principle that we were talking about in terms of drafting your arbitration agreement. It's a matter of giving fairly careful consideration to what is the nature of the dispute, which the name suggests, it says what it says on the tin, but what exactly ought one raise in an arbitral context? Now, this really comes down to the question of whether one can cut one's cloth to suit. The temptation often is to assert every possible cause of action arising from a series of facts, whether in law or in equity or in statute, seeking recovery of damages for all sorts of things: negligence, misleading and deceptive conduct, breach of contract, breach of warranty, etc., etc., etc. One of the things we wanted to emphasise here is that it is important to consider at this stage, what is your dispute? Do you need every one of those points? Is your case going to be better as a common law negligence suit as opposed to a breach of warranty case? Or if you may need the common law negligence suit for whatever reason, but do you really? And the temptation on the part of lawyers acting conservatively, and it's perfectly understandable, is to effectively put all the cards on the table so that you can run whatever might ultimately suit you best. But that can come with consequences. So, for example, going back to the Tesseract example, the reason that we ended up with an argument over proportionate liability is that in addition to the breach of contract claims that were available, which would not be susceptible to any proportionate liability defence because they were warranties and those sorts of things. And as practitioners would know, the proportionate liability regime does not apply to all causes of action, but only those where there's an allegation of a failure to take reasonable care. But it was necessary in that case because the action by Pascale against Tesseract, that was then known as Bryant Contractors, Bryant Consultants, I should say, which was a structural engineering firm, was that Pascale had been approached by Bunnings to tender on the design and construction of one of its warehouses. And it had been given a design brief, for want of a better description. It had gone to Bryant, now Tesseract, and said, look, can you help us out here, provide some preliminary sketches and designs, let us know what's involved so that we can price the steel, price the concrete that's involved in constructing this warehouse. Bryant provided that information and advice. Pascale proceeded to then tender. The tender was accepted. They entered into the contract on the basis of the tender. They started doing the work in accordance with the design that had been provided and obviously developed, because previously it was only conceptual. And they got about 3 or 4 months into the work and realised that, in fact, it was not going to stand up. It was structurally inadequate. They had to tear down the whole thing and basically rebuild it with a new design, obviously at Pascale's costs. So Pascale said that it had 2 causes of action, or at least one for the information provided upon which it relied to put in its tender, and then obviously the information that was provided for the discharge of its obligations to design and construct in accordance with certain features. Now, as a result, the first phase of the claims were in negligence and for misleading and deceptive conduct. Hence, we ran into a proportionate liability defence, at least in respect of those claims, and there are some cognate claims in statute in respect of the contractual works, but that's another day. The point of that little story is that if we had not had a claim in respect of the pre-contractual representations or conduct that we say was negligent, that we relied upon and then gave rise to loss and damage because we entered into a contract at a lesser price than we could have, and indeed on incorrect premises, Pascale may very well have been better served not bothering with any claim in negligence or misleading and deceptive conduct and simply making a contract claim, because that would have been within the terms of the arbitral agreement and would have only been between them and Tesseract, then Bryant, pursuant to the design services contract that had been made. So when drafting the notice of dispute, it's important to give careful consideration as to what the claims are, how they arise, but also, do you need every one of them, or are they going to be potentially more trouble than they're worth?
Do you think that the notices of dispute have more than less because of the fear that you can't amend?
I'm sure that's the case. I'm sure that one thing we all live in fear of is finding out at the end of the day, well, you could have run this case, but you didn't, and now you can't. And
in your case, hindsight.
Well, I mean, we still would have had to run the case, and we still are running the case. So, I mean, the proportionate liability defence is to be tested. Let me put it that way. But I certainly think that there is very much a concern. But having said that, it really is a case of, well, if you're not going to get up on your warranty case, if you have a warranty that the work will be fit for purpose, for example, are you really going to get up on a representation case which says that you represented that your design was going to be fit for purpose? And are those damages going to be any better than what you would get under a breach of contract case?
And arguably, you've got to get more evidence for a misleading assent to conduct case too.
Well, you have to prove reliance and all sorts of other things and what you did, et cetera, et cetera. I mean, that may not be difficult, and there may be a lot of overlap on that evidentiary Venn diagram, but there's no guarantee that that's the case.
I'd just like to make 2 points that follow on from that, and that's just to emphasise, going back to first principles, what is the purpose behind drafting an effective notice of dispute? And that is, it founds the jurisdiction of the arbitral tribunal. And that's really, I think, why those who are tasked with drafting the first draft of the notice of dispute generally put everything in the kitchen sink in it, because there's concern if they leave anything out, the tribunal will lack jurisdiction on an important aspect. But that then leads to overloading the notice full of material that is not necessarily relevant for the purpose behind drafting an effective notice of dispute. We've spoken about including causes of action that might have the problems that Frank's encountered in Tesseract. A related issue is, of course, the question of to what extent should every material fact be asserted in your notice of dispute, and just putting it in those terms, I think highlights that caution should be observed when embarking on that course. Also, in circumstances where how you frame a material fact, a party might wish to change the emphasis or not be in a position to know with certainty all the relevant details that go to the assertion of that material fact. So what we're suggesting is some circumspection when drafting the various elements that go to making an effective, valid notice of dispute.
All right, thank you. I think we can move on to the next slide. And we're now at our first procedural conference. We can probably move fairly quickly through this point, but because it's a circumstance that we may start to repeat ourselves somewhat. But it's usually at this point that one has to consider whether or not to seek or oppose orders to split or separate issues. And the ones that we've nominated here are obviously jurisdiction, liability and quantum. Now, that may have benefit. It's often thought that separate questions have benefit. Certainly, the view of most judges, if you approach them with a separate question, is very much against that. I think they consider them to be something of a false economy, and they present the appearance of economy and advancing the case, but often don't actually achieve that. That's not necessarily so much in arbitration, because obviously the risks on separate questions in litigation are appeal, and the fact that the case may go up and down, or further, whilst issues arising from the determination of a separate question are dealt with at intermediate or even higher level, and all the while the proceedings themselves are simply waiting in abeyance for determination. You don't have those problems necessarily, at least most readily in arbitration. But it's certainly a question that often arises, and it's one that the parties that we represent are often very keen on, because they certainly perceive the option or opportunity for savings. But it's certainly one that needs to be approached with great care, as the decision in CBI Constructors tells us.
Yeah, certainly.
I would like to invite discussion on this issue that I found particularly vexing, and that is In my experience, the arbitral tribunal and most solicitors will want procedural order number 1 to be programmed out to the hearing, and that is very often, say, 18 months away from the commencement of the arbitration, and it involves all sorts of steps in relation to discovery and expert evidence and things of that like. And of course, one has to do that at this, or consider that at this very early stage. And in my experience, there's often a tension between legal advisors as to whether that's actually feasible, practical, and should be done. And I don't know, Frank or Adele, if you want to comment on that.
You're right. There's always a tension in that regard as to whether or not there should be a full program, which almost inevitably starts departing from reality the day that it's actually ordered, and you almost always have to exercise liberty to apply to have the matter revised in terms of the procedural orders, because there's almost always inevitably slippage. One of the things, I suppose, and we'll come to this in the next slide, or maybe the next but one slide, concerns how one approaches the arbitration itself. Because I think the sort of procedural directions and the provisions for disclosure of discovery and the exchange of evidence is obviously going to be very different if the arbitration is undertaken using a more classic common law litigation style with pleadings and then orders for evidence and submissions, as opposed to the style which is favoured certainly internationally. I mean, it's becoming more common here domestically, which is the use of memorials, because those memorials will incorporate all of that material at the outset. So you don't have timetabling for evidence. You don't have those sorts of things. You don't even necessarily have much by way of submissions, because it's all in the narrative, which is represented in the memorial. So if your arbitration is going to be conducted using that approach, then those sorts of issues about procedural orders and whether or not you need to timetable everything up to and including the delivery of the award don't necessarily arise, because ordinarily there's a round of these memorials, then you get discovery, then you get the reply, and so it's very much a composite approach, if I can put it that way. So it really does depend on how your forum and how the parties wish to utilise the forum for the arbitration to need that sort of detailed procedural timetable or not, as the case may be.
I agree with you, Frank, in terms of that to timetable out the arbitration. It does depend on whether there is the more traditional statement of claim and defence or memorial. And as Frank said, we'll get to it, and there is a split on the panel as to who prefers memorial statement of claims. I sit in the memorial camp, and therefore I sit in the camp that...
The youngster prefers the memorial.
I much prefer the memorial.
The old greybeard likes the pleadings.
And I much prefer timetabling out, because it gets parties to think, what is the next step? And it does focus the mind in terms of when we do get to discovery, that hopefully the parties do understand what the issue is by reference to the narrative and to the evidence, which sometimes is missed with traditional statements of claim, and certainly we'll get to that. There is a halfway house, which I certainly don't recommend, and I have experienced this, where there's been a timetable for the preliminary parts of the arbitration, and that was done by way of a statement of claim and defence and evidence, and then the hearing, but no timetabling in respect of discovery or submissions or anything else. So it's left a very short time of which to exchange red phone schedules, to discover the material and then to look at it before the hearing. So I think it needs to be either just looking at pleadings, what we do in courts, pleadings, evidence, the more traditional form, or timetabling out, certainly not a halfway house.
The other thing that we'll also come to when we look at the question of memorials and statements of claim is what are you actually being asked to do when you prepare a statement of claim? Because the concept or the term statement of claim is somewhat protean. It means what it means in context. And indeed, many arbitral tribunals will refer to the delivery of a statement of claim by which they mean a memorial style document. and rather than what, as I say, myself as an old greybeard would regard as a statement of claim, which is a fairly concise, hopefully, statement of the relevant facts at issue and the relief claimed, and one doesn't plead law, one doesn't plead cases, one simply pleads the facts, and then those are matters for submission at a later stage. So one of the things we will need to be careful is if what practitioners need to be careful of is that if you go to a procedural conference and agree to provide a statement of claim, just be careful what you're agreeing to provide, because you may have one conception of it, but certainly pursuant to, say, the AKICA rules, there may be a very different conception of what you're expected to deliver, and it may be a very expensive exercise, and indeed a time-consuming exercise, to deliver that document, because it is supposed to incorporate as a composite, as we say, the documentary evidence, the witness statements, expert reports, arguments as to law, and claims for relief.
And I've had that arise in an arbitration where the AKICA rules applied, Rule 29, and it's titled.
We'll come to it.
Statement of claim.
Exactly.
But I don't want to preempt.
Exactly. So spoiler alert. Anyway, yes. Did we pass over one, or did we?
No.
We didn't. Okay. No. Good. Excellent. Well, we're here now. Adele, you're going to tell us about Rule 29 of the AKICA rules.
Yes,
and
Rule 29.
When it says statement of claim, it means?
Well, it means it shall include the following particulars, just the benign details of parties, and B, a statement of facts supporting the claim, C, the points at issue, D, the relief or remedy sought. So you could almost think there that that's reflective of what we know as the list statement in the T&C list here in New South Wales. But then says E, the legal grounds or arguments supporting the claim. And that's where I have found that there is a dispute as to what E encompasses.
There's also the next rule, 29.3, which...
Indeed.
Which says that the statement of claim should annex, as far as possible, all documents and other evidence on which it relies or contain references to them. So if one is obliged to proceed with a statement of claim as defined or described by the AKICA rules, one really needs to be ready to go with one's case as a claimant. Now, it's interesting that those rules are a little bit different, although I would suggest significantly different in those particular aspects to Section 23 of the Commercial Arbitration Act, because Section 23 of the Commercial Arbitration Act stipulates, subject to any contrary agreement of the parties. So if you agree AKICA rules, this doesn't apply. But if you don't agree rules of an arbitration, and we haven't come armed with the Dispute Resolution Institute's rules, but in any event, subsection 1 of Section 23 says that the statement of claim must state the facts, the points at issue, the relief or remedy sought, and the respondent must state the defence in the same particulars. And the parties may submit with their statements, not must, but may, all documents they consider to be relevant, or may add reference to the documents or other evidence they will submit, and either party may amend, or supplement the party's claim, etc., etc. So Section 23 of the Domestic Arbitration Act does have a somewhat different approach. It is very redolent of the AKICA rules and indeed the International Arbitration Act, but it is not so demanding as to the requirements, if I can put it that high, for a memorial-style narrative as part of your statement of claim. And it may very well be argued, and I think it would have certain force, that if you agree the AKICA rules, you are agreeing to a memorial-style approach to your arbitration, which requires preparation of pretty much your case in chief or your defence in chief in all respects. Would you agree with that, Stephen?
I would, and I want to. I'm in Frank's camp mostly on pleadings, but not completely. I think it's a horses for courses approach that I'd suggest. But I just want to raise this issue for consideration, and that is the problem in adopting a memorial style in circumstances where one has to include your expert evidence. And that's done at a very early stage where there may obviously not be a full joinder of issues, and your experts are being effectively asked to commit themselves at a very early stage. And invariably, it always happens that facts change when, as you understand your case as it goes, and there's a real problem of whether you've in fact committed yourself properly on your expert evidence. Has the horse bolted because of what your expert has done? So I think that's something that has to be at the forefront of one's mind when crafting a memorial style pleading, and that can mean that your experts have to be a little bit more general in their opinions, so they've got wriggle room to move later on if they have to. So I think that's an issue that I think is relevant.
Before Adele launches into her further advocacy of memorials, just to bring it back to the topic of the CPD, as Stephen said, it really is a horses for courses issue. But these choices in terms of the AKICA rules and these sorts of things are often made at the stage of when you're drafting your arbitration agreement. And so it's important to think at that point, look, what might be the disputes that arise? Are we prepared to, on a worst case scenario potentially, commit to a memorial style, assuming people know what that is at the front end, in terms of how this dispute is going to go? Because whilst they might think arbitration is cost effective, one of the points against the memorial style is that it does compel parties to spend a lot of money up front in terms of going to arbitration, because they've got to get effectively the witness statement is either finalised or in a very, very advanced state. The expert evidence needs to be finalised or in a very advanced state. You need to have all your documents organised and hyperlinked and able to be incorporated within a document that allows one to read electronically. And you need to have a strong narrative in terms of how this all fits together. So one of the reasons I prefer pleadings is that it doesn't commit the legal cost of getting your case ready to the extent that having to go with a memorial does, or at least can. What do you have to say about that?
I think, noting the time, one thing though that we were discussing prior to today was in terms of that, depending on whether you go through pleadings, as we call it generally that, or memorials, is that it does depend on the drafter. And what I've found in respect of where there's been a statement of claim in an arbitration is that it's not like when we're in litigation where it's expected that it will be amended. And I find that there is this resistance to amending statement of claims in arbitration. Now, that might just be my experience, but I find that then becomes difficult as you move along in the dispute, where, yes, there has been a joinder of issues, but when you have more technical evidence, not necessarily delay, but you then it's difficult to isolate those particular issues to then start to draft your categories for discovery. That's where I've found it. And then the issue becomes, well, is it an issue on the statement of claim? Does it arise? You can't point to your evidence. There's been no amendments of the statement of claim.
That's a very good rejoinder, and I have nothing but admiration for it. Okay, now if we go to the next one, we do notice the time, so we'll probably have to start moving a little bit more quickly. Emergency arbitration, interim relief.
I think what we want to say about that is that one should be familiar with the provisions in the AKICA rules which enable that, and the Commercial Arbitration Act. And procedurally, you may need to move very quickly before the arbitral tribunal is formed and seek interim relief. And of course, the emergency arbitrator would be somebody, usually a sole arbitrator, and somebody different to those who would later on be part of the arbitral tribunal. An issue in relation to emergency arbitration is the extent to which any decision or award issued by the emergency arbitrator can be enforceable. That's a developing area of law in Australia, and there isn't certainty on that position at present. Should we move to the next slide?
I think so. Again, this is a brief one. It doesn't really arise too much from the two High Court decisions that we've sought to focus on. But generally speaking, as Adele's already averted to, the question of document production, and we're really talking about inter partes here, discovery, disclosure, those sorts of things, is done these days through certain schedules, whether a Stern schedule or a Redfern schedule. I'm sure there's any other number
One's
of...
just tipped around the other way.
Yeah, one's in landscape, one's in portrait. But they basically require a category of document to be identified to further then say why it is material or relevant, having regard to the issues raised on the quote unquote pleadings or on the memorial, and if that production of that category is opposed, the reasons they're set out in a very brief form, and then there's usually a determination made on the papers as to whether or not the documents are to be produced, the categories of documents, I should say, are to be produced. So, I mean, this is obviously usually a very expensive exercise, a very time-consuming exercise, and
the categories are never agreed.
There's always reasons why something's not relevant.
Because the statement of claim's been used.
Yeah, maybe, or it's buried in a memorial somewhere, and you need to go through 16 different links to find out where it's said. But in any event, it's not really something that arose from the High Court decisions, but it's obviously a significant matter that costs a lot of money, and you can spend quite a deal of time on. Look, I'm not going to say discovery or disclosure is never significant, but it does seem to be a case of diminishing returns given the amount of money that's involved and what you actually usually end up turning up. I mean, the times that one's actually found a smoking gun are pretty rare. They're celebrated, but they're rare. Maybe they're celebrated because they're rare. I'm not sure. But in any event, let's keep moving, shall we? I suppose one of the most vexed issues that arises now that proportionate liability is available in arbitration is to the extent that proportionate liability is raised in litigation, but that party is not there. I mean, ordinarily they're joined if they can be, but if obviously they're no longer with us, either in body or in corporate form, then they can't be joined. And so then the question becomes, well, what does one do in terms of running the case? Do you have to effectively pick up the cudgels and defend the alleged concurrent wrongdoer so as to maximise recovery from the defendant that's there in front of you or the respondent that's there in front of you? And if so, how do you do it? You need to get documents out of them. Will they agree to give evidence for you, for example? These are all questions that arise in the context of arbitration. Obviously, subpoenas are available to get documents and to compel witnesses or at least obtain evidence.
Just in relation to that, Frank, I think it's pertinent to observe that issues like the power to issue a subpoena require the arbitral tribunal to consider that, and then that's often referred out as a power available to the court to actually issue, to order the issue of subpoenas to third parties. So there's a particular process that's got to be followed to enable that to occur.
Oh yes, there's no doubt about that. Yeah. You need to explain to the arbitrator why subpoenas ought be allowed, what the significance of them, and the production of documents. And sometimes the arbitrator will want to know whether or not this third party has been approached to produce these documents and all, and what their attitude is to production. I mean, and of course there is a complicating factor in all of this, is if this third party that you're seeking documents has been nominated in your arbitration as a potential concurrent wrongdoer, ought you disclose that to them when you are saying, by the way, would you rather like to come along and give me all your documents and give some evidence? I mean, that's an ethical issue that may often arise, and whilst this isn't an ethical CPD, I would have thought that it is incumbent, if you are seeking documents from a third party for the purposes of an arbitration, for them to be advised that they have been nominated as a concurrent wrongdoer, because that certainly can have an impact or effect, and it's the sort of information that they are entitled to know. And if you did not disclose it, then certainly as a practitioner I can envisage that various disciplinary bodies would have something to say about it. So if there is a concurrent wrongdoer...
I think there's a question from the floor, Frank.
Sean, thank you.
A question on that point you raised there.
Thank you, Sean.
Disclosing it to a third party.
Yes.
How might one do that if the parties have decided that their arbitration is
it's a very difficult question. I think you'd have to get the leave of the other party and indeed the leave of the arbitrator to do so. The question for those who are online who aren't, Sean's not close enough to the microphone. Sean Bailey has asked the question: how do you make a disclosure to a third party where the arbitral proceedings are confidential and private? And it's a very good and vexed question. It's not something that I've had to deal with previously, but I would have thought that it would be certainly within the power of the arbitrator to determine whether or not that disclosure should be allowed. Firstly, you would approach the other party by consent. There may even be substantive consequences of that procedural decision. If, for example, a cynical respondent said, "I'm going to nominate this third party, but I won't consent you telling them that I've done that, nor will I consent to you approaching them for documents, nor will I consent to you informing them otherwise that they're involved in the arbitral process." I mean, it may be within the arbitrator's scope to say, well, if you're going to take that attitude procedurally, which effectively, if not kneecaps, then certainly handicaps the ability of the claimant to deal with this defence you're running, I'm not going to let you run that defence. So that's certainly, I can certainly see that as a possibility. Whether or not they went through it in the end or not would be another matter. But I certainly think that if one wishes to assert that a third party is a concurrent wrongdoer, then one has to expect that there needs to be a degree of agreement to allow the preparation of evidence on the part of the claimant to actually deal with that allegation, which would include gathering evidence. Because one of the things that arose in Tesseract, just to go back to that, was that under the South Australian law, Section 11 said that where you have concurrent wrongdoers and there are subsequent proceedings, then the first decision in time is the judgment, which sets the damages for the claimant's recovery, the extent of the claimant's contributory negligence, and the extent of the concurrent wrongdoing of the first, of the defendants who are parties to that first action. And one of the things that we had to deal with in Tesseract and Pascale is, well, when that all occurs in an arbitration, which is private and confidential, and a third party never knows about it, how can it be reconciled with the fact that they are then presented with an award which binds them in those various respects? There is potentially an answer to that, which is that that third party could move for the award not to be enforceable under Section 34A of the Commercial Arbitration Act as a party who was not heard and who was not given the opportunity to participate in the arbitration, and therefore it couldn't be held enforceable against them. And there were analogues to those provisions in the South Australian statutes. But it certainly is an issue in terms of arbitration, because obviously in court proceedings it's all open, and the fact that you've been nominated as a concurrent wrongdoer, I mean, you're almost certainly going to get joined, or at least getting a letter about it. But it's certainly one of the difficulties that arises that I think Justices Edelman and Stewart were referring to about the consequences of the majority decision. I'm not sure we need to do too much more on evidence. I think we've covered that. We've probably covered hearings as well. As Sean has observed, these are private and confidential, particularly pursuant to the Akika rules. Rule 26 stipulates that. As far as the award is concerned, question of jurisdiction, functus, officio and CBI Contractors. Adele, you've pretty much dealt with all of that. Is there anything you want to add briefly?
No.
Okay. Well, that makes that one good. So then we have the question of enforcement, and again, just to get back to the question that we were talking about earlier from Sean, is that there are grounds for refusing recognition or enforcement, and there are grounds for setting aside as an exclusive recourse an arbitral award, Section 34 and Section 36 of the New South Wales Commercial Arbitration Act. And the circumstances in which an award may be set aside or indeed may be refused to be recognised are largely the same. One of the parties was under some incapacity. A party against whom the award is invoked was not given proper notice. So that goes to that point about Section 11 of the South Australian law that I was referring to earlier. The award deals with a dispute not contemplated by or falling within the terms of the submission to arbitration, and that goes back to the question of the notice of dispute and the extent to which the dispute, quote unquote, was the subject of the arbitration itself, or whether or not anyone or the tribunal is ranged outside the four corners of the dispute. The composition of the tribunal, or certainly in the case of Section 36, the award has not yet become binding. So they're the sorts of provisions that that render an award either liable or susceptible to be set aside, or as susceptible to be refused for recognition or enforcement. And when one looks at the decision of Chief Justice Gageler in the decision of Tesseract and Pascale, he was certainly very concerned, not so much with those factors, but the second factor, or the second set of factors, which was that the court finds the subject matter of the dispute is not capable of settlement by arbitration under the law of the state, or the award is in conflict with the public policy of the state. And those are also grounds upon which the court can consider that the award be dealt with other than through recognition and enforcement. There's probably not a lot more that I need to say about that in terms of Justice Gageler's decision, but it was certainly a factor that was motivating him as to whether or not the proportionate liability regime could apply, because he considered that the issue of proportionate liability, at least by reference to those key operative provisions as to a party only being liable to the extent of their wrongdoing, was capable of settlement by arbitration, even though the arbitral tribunal couldn't give full effect to the whole regime, and it was not contrary to the public policy with respect to the application of apportionment. Indeed, I haven't spoken a lot about the decision of Justices Jago and Beach-Jones, but they addressed the question of the public policy, both of the Commercial Arbitration Act and the proportionate liability regimes, and considered that the harmonious reconciliation of the public policy behind each of those statutes was to allow them both to operate, i.e. the key operative provisions of apportionment being available in arbitration. Is there anything anyone wants to add about enforcement?
No.
Well, noticing the time, and we've gone a couple of minutes over. Appeal, we've dealt with that, and that comes back to our notice of dispute point. Our arbitration agreement, doesn't it?
Yeah.
When the prospects of getting anyone to agree and appeal that they've been successful in an arbitration, I would have thought a snowball in hell. So, but I mean, it could happen, I suppose. I mean, would the model litigant provisions require
That's a good question.
The state of New South Wales, for example, to agree to an award? I doubt it, but it might be something that you would.
Yeah.
You'd certainly raise it if you're on the wrong side of an award. That would necessitate that they do so.
Mm.
I don't think anyone's tried that gambit yet, have they? Or if they have, they haven't succeeded.
Well, not that I'm aware.
Well, there we go. Something to take away from today. And obviously, there's the discretion. One needs to satisfy the various provisions of the Section 34A to demonstrate, public policy requirements, significance, etc., the usual sorts of provisions. Our last but one slide, the last slide simply headed questions, is whether one should arbitrate or litigate at all. Now, this is a question for the ages. Obviously, Justice Stewart thought probably not, or at least not in all circumstances. It really gets back to the matter that we were discussing earlier, which is think about what you're drafting for.
And I think just in relation to that, if you take this CBI and Chevron case that Adele explained at the outset, the arbitration commenced in 2017. The High Court delivered its decision last year in 2024. Mm. And I think if those responsible for drafting the arbitration agreement or that contract knew that it would take so long before there was any resolution, they might have decided otherwise than to choose arbitration as their dispute resolution model.
However, you can find the same sort of time limits in litigation.
You can indeed.
Not in the T&C list in New South Wales.
Well,
You're in the expedited list.
well, you say that, but I was before the Registrar of the Court of Appeal on Wednesday seeking a hearing date as soon as possible in circumstances where we were dealing with a claim which began in NCAT in 2016. Now, mind you, there was a significant period during which the parties were seeking to resolve the matter, but one of the benefits of arbitration is that it is final, and you don't run the risk of appeals and the case dragging on until either special leave is refused or you're all down in Canberra, unless, of course, you get a question of law arising out of the pleading, as we did in Pascale and Tesseract. But I mean, it certainly has advantages of privacy, confidentiality. Ordinarily can be quicker, although, as you say, the technology in construction is pretty good these days.
Yes.
But it really does depend on what your dispute is and what your clients want. And just the final note we've already mentioned, Section 8 of the Commercial Arbitration Act. If you choose arbitration, then you made your bed and you lie in it. And
well, the transactional lawyers have made the dispute lawyers' bed and we lie in it.
And 2 years later, you've come to the motel and all of a sudden your bed doesn't fit. So I mean, the matter that Stephen was referring to, I was also involved in. It relied on statements, reliance. It was estoppels, representations, the whole box and dice. But there was a query as to whether or not we would even have an oral hearing, let alone cross-examination, and whether or not we could possibly get it longer than a day. But obviously the other side had no interest in that at all. In fact, we're actively going to oppose it. So it was a dispute which was not suitable to the not necessarily not suitable to the forum of arbitration, but certainly not suited to the forum of arbitration under an expedited AKICA regime. So it just is, I think, a signal lesson that one needs to give consideration as to what you might end up in dispute about. We do have a slide, questions. If there are any, either online, I can't read that from here, doesn't look like it, but you can tell me if there are. Or indeed those that are kind enough to arrive and see us in person. If they would like to ask anything, then you may. You don't have to, but you may. Well, on that note of silence, I'll take that as we have covered every possible outcome, and there is nothing one wish to learn any more about arbitration in light of these two High Court decisions. Can I thank everyone for coming, and can I thank my co-presenters Stephen Ip and Adele Carr. Wish you all the best for the CPD season and trust that you all now have your points. So thank you very much.
Thank you for coming, everyone.
Thank you.